So we're going to start talking about the new agreement, kind of where we are on the LiRN process. I want to introduce, so you know Nathan and I, but this is Harold Van Winston. He is a partner at Templeman's, and he is the corporate counsel, the outside counsel that we retained to assist us. Just to give everyone background, because I know there's people.
This is a closed session, right?
Yes, it's a closed, it's an in-camera session. Sorry, I should have said that right away. So if anyone here is not from an association, we need you to step out. Okay, so, sorry, Ray. Thanks, Bridget. So I was trying to figure out when we started all this, and I don't need to go into too much background, but this has been kind of a stagnant issue for us for many years. You know that we had Library Co. We have Library Co. currently. You know that we had a transition board that was looking at trying to figure out how we would develop the library system into the future. That seemed to fall apart. We then looked at the LiRN concept, where we would go with a skills-based board. And I believe it was 18 months ago that we approved, in May of 2018, that we approved the skills-based board concept, and that we would then vet candidates, and we had a matrix. We hired a company that told us kind of what skills would make the board the most efficient for looking at libraries into the future. And so then we went and vetted candidates that had those skills. We vetted them through the summer of 2018. We reported to you in November of 2018 that we had been vetting candidates, and then Nathan was the individual for FOLA that was involved in doing all of the interviews. So once we done the interviews, all that needed to be done was we needed to change the agreement. And this is where I have to admit I was a little naive, because I had thought, well, we have a Library Co. agreement, we'll just make it the LiRN agreement. And what happened was we got a new agreement sent to us from the Law Society that had material differences. And so we had used the ad hoc and PRC committee members to kind of engage them and send them the documents, and concerns were raised. So that's when we decided to retain outside counsel. Harold was then able to go through the agreement, tell us the real life impacts of those changes, and that armed us for renegotiating with the Law Society. The original, or the current, unanimous shareholders agreement is not the greatest from our perspective. We have some vulnerabilities in that agreement. And so we knew that we were not going to be coming to a new position with respect to LiRN. We weren't going to be at a higher or enhanced position, but we wanted to make sure that we had certain protections for the law library so that unilateral steps couldn't be taken by the Law Society of Ontario. So what I'm hoping we can do is, we now have negotiated an agreement in principle. Today's motion is to give us the ability to execute that agreement. I thought that we would have Harold go through and give you the top line kind of changes that have been negotiated. And then if we do have a mover and a seconder, we would then have someone move and second the motion and then open it up for debate. So as long as anyone doesn't have any problem with that process, we then have the debate after the motion is moved and seconded, and then we can just put it to a formal vote. I'm not trying to thwart any questions during Harold's presentation, but if you wait to the debate, any of the three of us will try to answer any questions that you have. Okay? So Harold, do you want to walk through the agreement?
Sure.
Okay, so you want me to...
Here.
Okay.
Where do I point it at?
Point at the computer. There you go.
Okay.
Can you see it?
I've got it here.
Okay.
Good morning, everybody. This is really just a summary of the changes to the agreement that we've negotiated with the Law Society of Ontario. It is not a summary of the entire agreement. It's just a summary of those changes that we've made to the agreement they proposed, because the agreement they proposed basically took it from a situation where we had a certain amount of input to essentially being controlled entirely by the Law Society of Ontario. So that was the starting point of the agreement that they sent to us that we had to negotiate with. Understand that we weren't negotiating from a position of strength because the existing agreement had a provision that allowed the Law Society basically to set a sunset date on that agreement anytime they wanted to. And please understand, for those of you who understand corporate law, the only voting shareholder and equity shareholder in Library Co. is the Law Society of Ontario. We have, FOLA and TLA have non-voting preference shares, which have no equity and no vote. If they terminated the shareholders agreement, we'd be in a position where we have essentially very little rights, if no rights at all. So we weren't bargaining from a position of strength going into this, so we had to be very strategic and pick those issues that we thought were the most important. So what I start off with is this definition of extraordinary resolution. This was previously something that required only board approval. And because we're going to a skills-based board with no representatives essentially directly of FOL or TLA, we decided that we would like to have an extraordinary resolution require approval of either FOL or TLA, not just the Law Society people. So it was formally 5 of 8 members of the board of directors, but once this goes to a skills-based board, we'd essentially have no say on extraordinary resolutions at all. And so what we negotiated was a requirement that at least one of the FOLA or TLA must approve, as well as also extraordinary resolution. Extraordinary resolutions have to tie to something, so they tie to what we call material decisions. And there was a definition of material decisions in the existing agreement, and this is the full definition here, and it goes on a number of pages. But the important ones for us were under Roman numeral 5 and 6. We've added the shutdown or closure of any county law library association, and the closure of the law library, closure of the system or closure of an individual law library, other than a result of the fact that you stole all the money or something like that, extraordinarily. And then we have any material decrease in the funding of a county law library, which would result in a permanent reduction of their paid staff, and then the changes in the objectives and principles. Those last few changes are essentially what we've added to the material decision provision of the existing agreement to give us some more protection to the law library system. The previous board of directors was essentially an appointment process where I think it was four from Law Society, 3 from FOLA, and 1 from TLA, direct appointments. We're going to a skills-based board, and when you get a skills-based board, you're not really directly appointing people. You have a nominating committee who goes out and searches for the candidates that have that skill set. That's typically in modern governance for a nonprofit organization how you get a skills-based board. You can't just look around the room and say, put up your hand and volunteer. You don't get the requisite skills as have been identified. You end up having to really search for these people a lot of the time. And so it's now got a floating board of 5 to 8 as opposed to a fixed board of 8, and we've gone to a nominating committee. The original proposal from the Law Society was essentially that they control the nominating committee. And it was a bit of a struggle, but, and Law Society was very good through this, I think, that in terms of being reasonable in negotiations. We have now made it so that between FOLA and TLA, as we try to present a united front with TLA throughout this, we would appoint half of the representatives and they would appoint half of the representatives. So it's no longer a nominating committee that would be controlled by the Law Society. Yeah, that's just the discussion I had. We've added, this is the term of directors, and the main thing we've added here is a removal of director prior to their expiry of their term must be approved of the Law Society, at least one of FOLA or TLA, because as the sole voting shareholder, if it was otherwise it would have been them that had the sole and exclusive ability to remove any director, and we wanted to make sure that we had input and say into that. So that was a change that we negotiated into the thing. And then we have the governing principles. There's been some changes to that, necessary changes, but to some extent, perhaps it could be argued that there's some loss of certain things, protections we had in there. Please note that you're into a situation where everybody knows, the young lawyers today, they're all looking at, they're all doing their search. Nobody uses paper anymore. It's all electronic. Heck, they even use Google for law research and everything else these days. So it's a different world, and we have to recognize that the library co and the whole library environment is going to evolve and change. But we wanted to make sure that the libraries themselves represent something more than just books to each law association. So we did do that. This is just a section on the funding provisions, including the annual grants. I think that this is the one that we probably, if you have a concern of the agreement, that would be the greatest concern. There is the original push from the Law Society was basically to eliminate the so-called levy and designate it and call it a different name. Understand that the Law Society's always controlled the levy and always controlled the budget, and the budget has always been approved under the existing agreement as well. So that they're fundamentally, we don't control the budget. And so this changes to the wording have made it more flexible. That's a reflection and part of the skills-based board, because the skills-based board is going to look at the system, and that board is going to drive how this goes forward a bit more. And so there's always a risk when you go to a skills-based board that there's going to be changes. There may be changes that we don't like at FOLA, and there may be changes the Law Society doesn't like. And that's certainly a risk that you have to be aware of. What we tried to do to protect ourselves was to make sure that we weren't going to lose the funding so that we'd have a closure of law libraries. We felt that was a really important focus for this organization, and so that's why we built into the material decisions in a reaction to the funding changes. But you have to be aware that there's a possibility that the whole process may change, driven by the skills-based board. It's not driven by the Law Society agenda. That's the advantage of the skills-based board, is that it should be driven by the board. Law Society still, however, gets approval of the budget as they did previously. We walked into this, when I was told originally my marching orders on this, was we were in a position where, as indicated, we weren't bargaining from a position of strength. The Law Society had put on the table an agreement which substantially reduced our rights. We tried to focus on those particular areas, and in some areas we've got more rights in terms of material decisions and closing law libraries, something that we didn't have under the previous agreement. In some areas we've lost, but in balance I think we've probably come out at least equal to what the previous agreement does, and certainly much better than what was initially proposed. So in my view, I think we achieved about the best we could under the circumstances. The Law Society, I thought, was quite reasonable in their negotiations, and that's basically it.
Thank you, Harold. So we are in camera, and Harold hasn't dealt with the Law Society maybe as in the same ways that we have, where we have the suspicious hats on when we deal with the Law Society. But we did go to a meeting with the Law Society. I believe it was July 8th, where it was Mike Winward, Katie, myself, Nathan, Harold, members from the TLA, and then Diana Miles and some corporate lawyers from the Law Society. And that's where we kind of talked, about where we had reached an impasse, because we wanted to identify where our concerns were coming from, because at that point we weren't sure where things were going to go. And that's where we made a lot of headway by explaining what our concerns were. There is, when we look at, like, one of the things I ask all of you to do for consideration of this motion is realize that this is a step in order to allow the skills-based board, a concept that we've already approved, to be set up so that the libraries can start to function, or Library Co., or now LiRN, can start to function again, so that we can then make a push for more funding. So there have been some comments and questions raised to us in our consultation where individual associations have raised concerns with the stagnant funding, and we're very aware of that. That's been going on a long time. I remember a presentation by Mike Ross years ago where he showed that with the stagnant 2%, our funding was being decreased because, you know, loose leaves or different costs were going up greater than 2%. And so we're trying to get through this hurdle so that we can then make the big push for more funding. We do have some, you know, commitments is a too strong a word, but we have had letters from Treasurer Shabis and individuals in the past that have said that they are willing to advocate for more funding, but they want the library system to operate, to function more properly. And in our initial discussions with Harold, I mean, the skills-based board is what a modern governance structure is. So while, you know, we're happy to discuss any of the clauses, please know that we're not talking about maintaining funding, and we're not talking about accepting certain things as they are. We're trying to make sure that LiRN can get up and running, and then it will be up to us, and Nathan can talk about this after we decide, after the vote is taken and we determine what direction we're going. But it will, if this is passed and we execute this agreement, that is only a baby step. The next work, it's been a lot of work and a lot of struggle to get this agreement and get the skills-based board, but that's just the beginning. And what my biggest fear is that this will get in place and then we will become complacent, because it will be working with the skills-based board and demonstrating what our library system does, what all of our associations do that is critical to competence, why we need more funding, and demonstrate the needs to modernize our services. That's where the real work, in my view, comes into play. And my concern is that I don't want to take the foot off the gas just because this one corporate step has been achieved or not achieved, depending on how the vote goes. So with that being said, what I'd like to do is see if we have the motion. The motion was circulated, and we did that. We knew it was a critical motion, so we wanted to make sure we circulated it at the beginning of October so that every association would have a chance to review with your respective boards so that you could come here with authority. And I want to thank Eldon Horner for doing the lion's share of drafting that motion. But can we just, for the purposes of moving the motion discussion forward, is there someone that will move the motion? Can you state your, I don't know if anyone has said this, but if you speak at the microphone, make sure you say who you are and what association you're from for any of the discussions in plenary, because we record it and we would like to know who's actually saying what and where you're from in what association.
So Catherine Whitehead, President of Simcoe Law Association. I move that we instruct plenary to, or that plenary instruct the executive of the Federation of Ontario Law Associations to execute the amended and reinstated unanimous shareholder agreement.
Okay. Do we have, now there is a motion, so is that the motion that you're moving to approve that motion?
I'm moving to approve it.
Okay. Do we have a second?
I'm Gord Prisco from Nipissing, and simply I second the motion.
Thank you. Okay, so now it's time for all of you, anyone who has some questions, concerns, wants to debate anything, to let us know what you're thinking.
Karen Yulin, Middlesex Law Association. I am stepping in today on behalf of our Vice President, who has been very engaged in this particular discussion. We did have a discussion at our board when the motion was circulated, so thank you for that in advance. I did receive an email this morning raising some questions that I think that I should bring to your attention right now. The first being concerns about the 3 members of the nominating committee making quorum. Since three of the six are from the LSO, they could potentially be making all the decisions. And could it be so that we have one of the quorum from TLA, one from FOLA, and one from the LSO?
I don't think we can say one from each, because that puts the associations in an enhanced position. And so I take your point, and I mean, the fact is that whoever we put on the nominating committee, we would expect to be in attendance at any, if there's somebody that we're going to appoint to a nominating committee and they're not attending, that's a bit of a problem, right? Because the nominating committee's role is limited, right? It's just to nominate people for the board. It's not for the operational.
No, and it's a matter, there's a risk there. There's also a risk the other side. I mean, theoretically, we could have a nominating committee where the two FOLA members and the TLA member shows up and there's no LSO member, so the risk is the other side.
There's one. They'd have to.
No?
Oh, yeah, that's right.
No, the risk is both ways.
Yeah.
It is a risk, but on a practical level, nominating committees don't meet that often, and it's a matter of making sure our nominating person attends that meeting, that at least one of them attend the meeting. It's important that they all attend, frankly, because you're going to have a majority vote, and it's not just a matter of 3 and 3 in the quorum. What happens if we only have one representative from FOLA and TLA, and there's 3 from Law Society? We get outvoted every time. Yeah. So it's not just a matter of the quorum. I think that's not. It's actually, you think about the decision making when you're making a nomination. It's balanced. That means we have to have pretty good attendance, or if we consistently have our nominees not showing up and their nominees showing up in full, we're going to get outvoted each time. That's a practical matter that has to be addressed. So there's risks both ways. The risk to them too, if their people don't show up, we could consistently outvote them.
So somewhat related to that then, what about the position of the chair, and does that make a difference of whether or not that's rotating? The chair of the nominating committee.
Chairs of a nominating committee, unless they have a second or casting vote, don't really make a difference. Typically speaking, they're just the person who organizes the meeting and sets the time frame. So it does have some impact on a practical level. And, it's not something, it was hard enough to get it to 50-50, and, at a certain point you say, well, we accomplished the main thing we wanted, and we left it at that, basically. Like I said, there's risks both ways.
Okay.
Now, before they controlled entirely on their initial proposal.
Hi, Eldon Horner, past chair, co-chair of real estate. I have a quick comment and then a quick question. First, for those of you who haven't been here for many years, I just want to say this has been ongoing for 7 or 8 years. It really came to a head in 2014 when Cheryl Saran and I attended a meeting with then Rob Lapper and Janet Miner, who suggested that we throw the whole thing out, just end it that day and dissolve the corporation. That meeting didn't go well. It led to 5 years of this process. And my comment is, I think hopefully everybody in the room will see that nothing's perfect, but this is a really good solution. It's about as good a protection as we could possibly hope for, I think, so that's my opinion. And I think your current executive really deserves a lot of credit. Mike Winward said he would never deal with libraries, and it had to be done before if he was going to agree to ever become the chair. Sorry. But I think Jay and Nathan have done a wonderful job, and I'm really glad we had Harold to help out with this process. So I'm just going to commend them for their work and tell you that, again, in my humble opinion, which I don't get to vote, is that this is a good thing. And second, at that meeting in 2014, I was hugging the unanimous shareholders agreement at the meeting, literally, and then it was made fun of repeatedly after that. Can I have a copy of the new one if it gets signed?
Thanks, Eldon. Yeah, it is important for us to understand that this has been a long process. We have tried to engage people who are interested. I think actually Middlesex was on the PRC and ad hoc committee, and so we have tried to reach out and make sure that you're as comfortable as possible with this. But, and I know it's intimidating for those who have not been here to plenary. It's kind of intimidating to come up to the microphones, but it really is an important vote. So I do want to make sure people are feeling comfortable, or if they're not feeling comfortable, we have an understanding of why. So does anyone else have anything else they want to put as a question? Okay, well, then I guess it is time to vote. So what I propose to do is go by a show of hands unless it's close, and if it is close, then what we do is we kind of do a roll call of just your vote from each association. If it's not close, then unless we want to record the nays, I would just have it carried. Does anyone have a problem with a show of hands?
Remembering as well that only the president or the designate can vote, so if you have multiple members here.
You don't get more than one vote.
Don't everybody vote.
Okay, so all in favor, can you please raise your hand? So thank you. I don't think it's close. Do you want me to put anyone who's
Yes.
opposed? Anyone opposed, can you please raise your hand? Very funny. The non-voting person from my association just put up her hand.
Any abstentions?
That's right.
Any abstentions?
Any abstentions?
No. Carried
All right,
unanimously.
carried unanimously. Thank you very much. So I just wanted to, with the time, because we have about 10 more minutes, I wanted to have Nathan go over next steps, because I think my time with LiRN might be done. I think this is it. So
Thank you, Jay, for doing all of the work that has now got us to a starting line, because that's really where we're at now. This is not mission accomplished. We're at the end. We are now successfully at the beginning of something new. We are planning now to amalgamate the ad hoc committee and the practice resource center or library committees into one smaller, a little bit more nimble group of sort of 6 to 8, maintaining some librarian representation on that committee, but also some regional support throughout. Remembering that we are now going to be providing input to a skills-based board. We are not directly running the corporation anymore. So what we need to be making sure that we are doing is that we are engaging. We engage, we engage, we engage. Engagement is key during this initial setup time. The board is expected to engage with stakeholders as well. They will be hiring an executive director likely, and possibly other staff. We need to be engaging with them from the outset to say, this is what is key. So anybody who is interested in being on that committee, who is interested in driving this forward, please speak to me over the course of the next 2 days. Please reach out to me by email. If there's somebody in your association who's interested, who's not in the room today, please make sure that they are engaged, because we want to make sure we have as wide of a representation as possible. We need to eliminate the apathy that often surrounds libraries. The libraries are the heart of all of our associations. Without the libraries, most of the associations would die, at least in my opinion. So we need to make sure that the librarians have the support of the lawyers. Every librarian out there, and I see a few of them smiling at me now, know that this is a huge issue. This is their job. This is the association as well. But if the lawyers sit back and we say, we've got it here, we've signed the agreement, let the skills-based board go, you may not like where we end up. So please, please, please make sure that, as I say, this is a starting line, not an ending line. The Law Society has committed a number of times from a number of different people, and we again need to be engaging the benchers as well as we go ahead here. They are committed to receiving budgetary suggestions from the skills-based board and saying that if this is what you need to accomplish what we think libraries and practice resource centers, and we're calling them 100 different things, but in the end, if we're really committed to competency, what we need from funding to achieve competency is what they are willing to spend. but we need to justify it, and we need to be able to engage the skills-based board and engage the new ED that probably will come into force in the first or second quarter of next year to say, this is what we need and why we need it. We can't just say, we need more money because we always need more money. We need to be ready to innovate and suggest that this is the new way that we can provide competency to the profession. So make sure that we are engaged so that we can make those recommendations and our voice can be heard.
Okay, so I think that's it. I do want to specifically thank Harold.
Yes.
Again, I think I made the joke in May about how suddenly, you know, we were struggling with these, this agreement, and suddenly I think it was Eldon had this fabulous suggestion in the April executive of why don't we hire outside counsel? And I'm like, that is fantastic. What a great idea that is. And so he has really been a great lifeline for us, seeing this from an objective point of view. It is important that we have hired somebody who does have the experience, but also the objectivity, and can look at the agreement from that point of view. We kind of jumped in, met some tough timelines that we had to give him in order to try to get everything in order for today. And so if we could all just thank Harold for all of his hard work, please.